Good afternoon, everyone, and welcome to this workshop on going from a student visa to a green card. I'm glad you could join us. I'd like to introduce our host of this workshop, Raju Mahajan. Raju, you have a long history with the graduate school at UNC Charlotte. You and various members of your team have done quite a few workshops like this for us. And Raju is also our sponsor for 3 Minute Thesis last year and this year. So it's wonderful to have you back here. And I know you're joined by some of your team members at Raju Law. We have Anna Quintero, Meheg Galani, Chelsea Smith, and Rachel Gilbert all joining you today. So thank you to all of you for taking the time out to help our students with this process that is not easy to navigate, and I'm sure they appreciate all this great support you're giving them. So thank you, and I'll hand it over to you.
Thank you very much, Jill. Let me share my screen. All right, thank you very much, Jill. And as you mentioned, I have a long history with UNCC. I was never a student at UNCC, but I used to live right next to the campus within a couple of minutes walking. I think it's called UT North. There's an apartment complex. I used to live there for 1 year while I was in Charlotte. And I think this is our third or fourth year doing this kind of seminars and many other working together. I really enjoy talking to you, Aura, or Nicholas, and everybody from your campus. Last November, I was there. This November, I'll be there again. And this is just, as I said, this is just the beginning of our long partnership. I really like to be more involved. This April I visited Ghana, and I mentioned to you that I took some of the promotional material. This coming February or March, I'm visiting Ghana, Nigeria again, and I would like to represent in an unofficial capacity UNCC. So, and also I really thank you and your office for giving us the opportunity to talk in front of students, because I was an international student too. And, I remember when I was an international student, I had to go to a law office to talk in person and, get all the information. It was difficult for me because that time I didn't have any car. So a lot of international students, when they come to America, they study, they focus on education. Many of them cannot afford going to an immigration lawyer. Many of them do not have like a car, transportation. So it's difficult for them to reach out to attorneys. That's why I try to reach out to international students. Of course, we'll probably make some money out of here, but at the same time, my main motivation is to give information as much possible so that they can help themselves. And if they need any help, definitely your office will help them. I am here, me and our team, we're going to help international students. So I really appreciate this opportunity. So without any further delay, I'm going to the presentation directly because everybody's waiting for that. So these are the talking points. I'll just go by talking points. If anybody has any question, you can ask me now, or you can actually ask all the questions after the session. Probably we'll talk almost an hour total, and then, or probably 45 to an hour, and then you can ask questions about anything, like literally anything about immigration. Even if you have some personal question, I'm happy to answer if I know the answer. If not, I'll tell you I do not know the answer. So the very first thing as international students you will face is OPT and CPT. So there are two kinds of OPT, and OPT stands for optional practical training. So it is related to your field of study. And there are two kinds of OPT. One is pre-completion OPT, another one is post-completion OPT. So pre-completion OPT meaning you are taking this time, the permission to work off campus. You already know that as an international student, you are only allowed to work 20 hours per week on campus. However, under OPT, you can take permission from your school and go off campus and work related to field, related to your education. So one thing you must remember, anytime you take before graduation will be deducted from your post-completion OPT. So there are 1 year of OPT for all students, and after 1 year of OPT, there are additional 2 years of STEM OPT for STEM students. STEM stands for science, technology, engineering, and mathematics. So non-STEM students, you will get 1 year of OPT. STEM students, you will get total 3 years of OPT. However, if you take some time before your graduation under OPT, that time is going to be deducted from your first 1 year of OPT. Meaning, let's say in 2 summers, you are taking 3 months, 3 months, total 6 months OPT. Then this 6 months will be deducted from your first 1 year of OPT. And then if you're a STEM student, definitely will get 2 more years. But if you're non-STEM students, you're losing significant time from your post-completion OPT. That's why I encourage students not to take OPT before their graduation, especially if they're non-STEM students, because post-completion OPT is really, really helpful to get job and other kind of benefits. So please know about this. Oh, by the way, another information I must tell you, as an international student, your local guardian is your school international office, especially DSO, designated school officials. They are your local guardian. For any reason, or even without any reason, I advise you to contact your international students at international student office at least once a month, no matter what. Even if you do not need anything, just go there, say hi, have very good relationship, for Thanksgiving or Christmas. If you can bring some gift for them, that is really going to help you. So please have a good relationship with your international office, especially with DSOs, and they can keep you posted about all the latest updates about international students and everything. So this is really helpful. Okay. On the other hand, CPT stands for Curricular Practical Training. CPT you can take anytime, especially before graduation, you can take CPT. And CPT is actually part of your curriculum. It's not a special privilege, it's a part of your curriculum. So not all universities, not all programs have a same number of CPT. Some program may have 3 months of CPT. So it's kind of like a course. You can consider it as a course. Some school even will offer you credit for CPT. Some school will not offer credits, but you'll just get a permission to work off campus in the field related to your education. Some school will even offer you almost 1 year, usually 11 months of CPT, which is very helpful to get some practical experience, get some good communication with industry, and try to get a job. However, before you apply for any job, talk to your international office, know about the length of your CPT, maximum length of your CPT allowed for your program, and then you plan. Because a lot of times students reach out to corporations and they ask about CPT and they say, oh yeah, we have CPT for 11 months. But in reality, their school only allows, let's say, 6 months of CPT for that particular program. So you must know before you apply for a job or anything, it's really going to help you. STEM OPT, as I said, is only for STEM students. Now, the question is, a lot of students they even don't know whether their subject is a STEM subject or non-STEM subject, because a growing number of universities, what they do, they kind of add some STEM courses in a non-STEM program and try to designate it as a STEM subject, because STEM subjects get a lot of federal funding, state funding, and also students get 2 years of additional OPT. It's kind of good for university. So a good example is MBA. Recently, I see a lot of MBA. They add some science, like business analytics kind of courses, and they try to get designate this subject as a STEM subject. So whether a program is a STEM subject or not, a STEM program or not, you must know it from your international office. Again, they will tell you everything, whether this MBA program or that master's program or that undergrad program, whether it's a STEM program or not, you have to know it before you make any major decision, because it makes a lot of difference. Another program is called Day One CPT. This is a very unique and very, sometimes people think it's an illegal program, but it's not illegal at all. It's approved by the federal government. It sounds very fishy, but it's an official program. So, a lot of students from all over the world, they come to America to get education, and after education, they go to different work visa to work here. Sometimes they are out of those work visas, especially H-1B. Our supervising attorney, Chelsea Smith, is going to talk about H-1B in a minute, but let's say you went to H-1B, you already passed 6 years of H-1B, and you are no way to extend it. So, or any other reason, let's say you were in STEM OPT and your STEM OPT is over, you could not go to H-1B or other kind of visa. In that situation, day one CPT is going to really help you. So not all universities, not all programs are authorized to offer day one CPT. You have to call university and know about whether they have any day one CPT approved programs. So the easiest way to do is just Google it. Like you can say, you can write in Google day one CPT programs near me, and definitely all the universities they are authorized. They will pop up, and you can call them. There are some very famous universities who have day one CPT program, like Vanderbilt University in Tennessee. Also, there are some very not so famous kind of universities. So and also in Vanderbilt University, not all programs are authorized for day one CPT. So you have to check individual program whether they are day one CPT approved or not, and also their international office will tell you. In general, you have to be within the same field of your previous education, but it's not mandatory. Some school will admit you even without any prior experience. So let me give you an example. So let's say your master's degree was in geography and it was a non-STEM program. So after getting master's in geography, you got 1 year of OPT, your 1 year is over. Now you do not have any other options. Now you're gonna go for a day one CPT program and you did not find any day one CPT master's or PhD program in geography. Then some university will get you admitted for, let's say, master's in IT or PhD in IT program under day one CPT. Some university will not do it. So it depends on the university, depends on the program. Now the question is, why day one CPT is so important? Why day one CPT is so, it sounds like very good deal. Because under day one CPT program, you will get a work permit in the day one from the very first day, and you will rarely need to go to university to get education. That's why a lot of people like, how come this is a formal, this is a legal thing? So the logic behind day one CPT is you already got education, you already want to work, but because of some limitation in American immigration system, American government is giving you opportunity. If you get admitted to day one CPT program, you will get work authorization in day one. You will keep working, and your education will be kind of part-time. So most of the universities, most of the program will just require you going one time a semester, just write one paper or taking one exam a semester, so that you can focus more on your work rather than education. So it's kind of like basically a work visa in the form of education, but it's 100% legal. There's no problem with that. If you have any question about day one CPT, we'll definitely answer later. Another important thing I would like to tell you is economic hardship work authorization. So as an international student, you are only allowed to work 20 hours per week on campus. And by on campus, your payroll must run by the university. In a lot of university campuses, they have restaurants like McDonald's, Subway, Taco Bell. If you work for those corporations, those are not allowed under a student visa because your salary is coming from a corporation, not university. So as an international student, you are only authorized to work on campus if your payroll is run by the university. However, under certain circumstances, you can apply for economic hardship work authorization if situation in your home country got changed because of some unforeseeable circumstance, unforeseeable reason. Let's say your country went through some severe financial crisis, some political disaster, or some hurricane, storm, or one of your parents or significant family member died, and because of that you are experiencing economic hardship, and it happened after you came to America, then you can apply for economic hardship work authorization. They will usually allow you one time for 1 year, but sometime you can apply if the economic hardship condition continues to get renewal after every year. So this economic hardship work authorization will only be approved if you are already enrolled for a full-time position. There are some other requirements. I'm not going that detail into this thing, but economic hardship work authorization is another important tool if you want to work off campus during your education. So now it's time for H-1B and H-4. I'm inviting Chelsea Smith, our supervising attorney, to talk about H-1B. Chelsea, are you going to present any PowerPoint?
I have some slides to share. Yes.
Perfect. Okay, perfect.
Thank you all for having me today. My topic is going to be on the H-1B visa. The H-1B visa is a very unique classification within the employment-based visa program. It is for people with specialty occupations. However, it has like a dual intent visa, basically. For specialty occupations, it requires a minimum of a master's degree or an equivalent experience. The basic H-1B is valid for up to 3 years. However, it's extendable for up to 6 years, possibly longer if you meet certain criteria. Here is a basic visual concept of what the H-1B visa journey could look like. It consists of 5 steps. The first step is, because it's an employment-sponsored visa, the very first step is that your employer would have to file the labor condition application with the DOL. Once that gets approved, then your employer can then submit the I-129. We will discuss all of these steps. I just wanted to provide you with a roadmap of the 5 steps. The third step, which is the one everyone is most familiar with, which is the lottery system. The next is the visa processing. And then finally, the 5th step is the visa being issued to you, your H-1B, and the start of your employment. So you can see it's a very complex journey for those who are of specialty occupation. It tends to be very cumbersome, but it's very rewarding, and it is a very good strategy for those who may be coming from their education and entering the workforce and have long-term goals of maybe citizenship. Maybe they don't know initially, but it's a good stepping stone following an education program or entry into the United States. It's governed by the Immigration and Nationality Act of 1952, which has since been amended in the H-1B Reform Act of 2004 and the American Competitiveness and Workforce Improvement Act of 1998. Regulations are set forth in the CFR, Part 655, Subparts H and I. Here's some basic overview of eligibility criteria and annual limits. As I mentioned, it's an employment-sponsored visa for those who are of a specialty occupation and have a higher educational degree or equivalent. There is an annual cap, just like with most other visas, and I'm providing a summary of the recent trends so that you can see how competitive this visa is. It's very popular, and we can see that there's a total number of registrations for each year between 2021 and 2024. In comparison, more than 700,000, almost 800,000 applicants or registrants, compared to less than 200,000 individuals that were selected. And, it is worth noting that there's a number of reasons for rejection or not getting selected. Registrants themselves, as I mentioned before, there were 5 steps in this process, and it gets initiated, different things happen. Maybe the position didn't fall through, the position fell through with the employer. So it's not just the lottery that speaks to the selection, but it is a major factor, and it is something that complicates the H-1B visa. The agency is involved in these multi-steps of the H-1B, which is different than some of the other visas that primarily deal with the USCIS, because the employer has to have the position, the LCA approved. They work with the U.S. Department of Labor, then the USCIS gets involved, and the Department of State actually issues the visa. There's also governance by the Wage and Hour Division of the U.S. Department of Labor, which is kind of an ongoing compliance regulatory system that's in place as the employer strives to meet the LCA obligations. So when I mentioned the employer compliance, there's some things that so the thing to remember is that the employer is the one filing for this visa, and the beneficiary is going to be the immigrant who wants to have this H-1B classification. So they must identify that individual. The employer must identify the individual, the worker's occupation, the number of H-1B workers that they seek, the rate that they plan to pay, the period of employment. They must specify the work location, give additional details regarding the prevailing wage rate, and the source of, where that would come from, whether the employer is also H-1B dependent. And so those are some business structure things that go into play in the background that it applies. I share this information because I think that it's important to realize how cumbersome it can be for an employer and how much of an investment it is from an employer standpoint. It's definitely speaks to why this process is so complicated and why it is both advantageous and a risk for an employer to sponsor this. I'm going to speak to more of that question as well. People come to us and ask questions about portability for the H-1B. So portability can mean different things for different visas. And the interesting thing about the H-1B is that if for any reason your employment with the initial sponsor or the initial employer were to end, whether layoff, whether you just need to change your role for different reasons, there's a lot of factors that come into play for why. And the thing that's really neat about the H-1B is that there is portability, and all it requires is that your new employer either submits an additional I-129 for the employment of the H-1B worker. In addition, the new employer should also update that labor condition application, LCA, just making sure that it covers the same work and that there is still alignment with that initial H-1B classification. So for example, if you are someone who has a master's in, let's say you have a computer science master's and you're working as some kind of analyst, performing traditional computer science skills. And your new employer is in marketing, right? It may be advantageous to a marketing company to have a computer science master's employee, but that would represent a misalignment to your initial LCA application, right? And so what the USCIS or what the regulatory compliance side is looking for is they're wanting continuity between jobs that you may have. It's not wrong to have more than one job or to switch employers, but they're looking for you, if you're a computer science master's, to continue working as a computer science master's. And that can mean a number of things. You could hold probably a variety of positions with that degree, but the skills need to be similar and it needs to require the same master's degree from position to position, if that makes sense. So the benefits of portability are kind of intuitive. It enables an H-1B worker to be able to change your job without risking the lapse of your with your visa, right? And the other provision, it also enables an employer to bring in an H-1B non-immigrant worker sooner than if you were having to go through the process each and every time you change jobs, right? So the theory is that, the process is so cumbersome, there's an acknowledgement of how difficult that process is. If a visa can generally be good for up to 6 years with possible extensions, then, wouldn't it be advantageous to then provide portability? And the answer is yes. They've determined that there is an advantage to that mutually. Which brings us to the idea of extensions. Initially, the H-1B is good for 3 years and can grant extensions for an additional 3 years. Extensions can be in 1 year or 3-year increments based on various factors that may apply to the visa holder. There is a matrix that we follow. I'm going to outline that quickly for you. One of the most common ways to get an extension is for the employers who basically say that they still the employer to file evidence of an approved I-140 petition, or that the I-140 petition was filed at least a year before the end of the 6th year of the requested H-1B start date. So it gets a little bit complicated in terms of timing. It works well to have, keep all of your deadlines kind of neatly organized and informed so that you can see how just tricky timelines can come into play for eligibility here. The other way that we like to, and this is really helpful for individuals who may have a birth country with a long priority date waiting period. So I immediately think of India, China, those kinds of countries that may have really long priority dates. H-1B status can be a very helpful tool for these people who may have an NIW that's been approved, but we're just waiting long periods of time for that adjustment of status to be able to be filed. The H-1B can be extremely advantageous in this regard because an approved I-140 could then get you additional beyond that 6-year extension, because it's an acknowledgement that you're here. The USCIS has determined you have exceptional ability and that you're on a path to a green card. Therefore, the H-1B extension makes a lot of sense. And in order to obtain that additional extension beyond the 6 years, all you have to do is file a copy of that I-140 approval notice showing that the priority date is not yet current. And so you can get your extensions that way. And it allows you to continue working. It allows you to have continuity while you're waiting on that priority date. So we currently see that quite a bit for our H-1B clients. This strategy tends to work very well and provides a lot of stability and consistency. It keeps people here that want to be here, continues to fortify our industries. I have a couple of quick samples. This is basically saying the same thing that we just discussed, but it adds the factor of spouses. A lot for the H-1B, spouses generally are not able to work as a H-4 dependent. And the other piece to add here is that travel, generally you can travel in and out of the US using your H-1B documentation. There's generally no problems there. I have a couple of other things here to add in terms of spouses and their employment. Once you have an approved I-140, your spouse may be eligible then for an EAD to work. And again, traveling you're still able to use your H-1B documents with an approved I-140 and an H-1B because until that adjustment of status occurs, your H-1B is your current visa. So that's an important little nuance to keep in mind. And just to summarize, the key features and advantages of the H-1B visa is that it's a dual intent visa with a pathway to permanent residency through usually the I-140 application, the NIW. Some clients may qualify for an EB-1, but generally the EB-2 is the pathway to permanent residency. It has great portability, allows for job transfer, mobility, and the ability for H-1B sponsors to then bring in immigrants to work in their workforce and contribute to the fortification and just enhancement of any industry. it allows for spouses and children to come to the U.S. as well under age 4, and with certain situations, spouses may be able to work. Generally, that's really restricted to people who have the H-1B and an approved I-140 and are waiting on that priority date. Also, lastly, there's the ability of possible extensions. We've covered what some of those things can look like. The real disadvantages come back to the stress of that annual cap and the restriction to have the master's degree. It can be a shorter initial stay. But like I said, there's still also options for extensions. So it really depends on a case-by-case evaluation. Lastly, that labor condition application requirement is a stressful step for employers. It's costly. There's a lot of financial obligation for employers, which may not make it feasible for some organizations to even sponsor H-1B visas. So that can be a disadvantage as well. And to wrap up, I will cover some of the current challenges that we're seeing is generally this U.S. lottery system for skilled workers. It sets the tone that it relies on chance rather than merit. And so some people feel that that's unjustified. They feel like in a pool of so many applicants that there should be kind of like a hierarchy based on how distinguished you are amongst your other cohorts who are also applying. So there's some discussion around that. The employer financial burden is difficult. There's also the worry about just layoffs and the economy in general. But the benefit of the H-1B is that, as I mentioned before, the H-1B, it tends to be a great visa option for maybe U.S. immigrants who are enrolled in the U.S. education system and at our universities. And so it makes enrolling in these universities really appealing if they know that an H-1B can be available as an option afterward. Raju touched on the value of the OPT STEM, Day 1 CPT, which that definitely also helps continue to make U.S. education attractive for immigrants. But the visa strategies can be very complicated and confusing. So it's definitely important to get plugged in with either an immigration attorney or your school system to help you navigate which visa suits you best following your graduation. Also, the ripple effect is if H-1B becomes, for some reason, less attractive, then that automatically means that we have a less diversified work field. And the purpose of the H-1B was to bring talent here, specialized field, diversify our workforce, and also aid in global competitiveness in some of the most leading issues of our economy, of our national interests and values. So if immigrants cannot be included because of an overly complicated H-1B process or overly complicated visa program, then that really limits our ability as a nation to then impact as well. So I also found just a quick statistic that according to the 2016 report, that immigrants contribute to about 14 to 15% of the U.S. economy's GDP, despite really only accounting for only 13% of the total U.S. population. And the lottery system is stated to contribute to basically a shortage of skilled workers. And this is something that policymakers are, you currently see a lot of lobbying for the H-1B policy to be changed from a lottery system to more of a merit-based award. So that could be something that gets some traction over the years. But, currently it's still the lottery system. It still is what it is, flawed or not. And just we continue to work with our clients, work with the community to try to navigate visa strategies that work best for everyone's circumstances. This is an estimated timeline, just another visual to show you how those 6 progressive steps begin. You could start in February and potentially end in October. It's it's a very long process, several months long, several steps, but ultimately, the hardest part is coming out of the lottery for most people. And that's all. That's all I have. Thank you for your time. If there's any questions, we can take those or move on.
Yeah, thank you very much, Chelsea. We'll have like a question answer at the end of everything. So I am going to talk about, now it's time for EB2. So there are 2 EB2 sections. One is called regular EB2. I'm going to talk short description of regular EB2. And after that, I'm going to invite Rachel Gilbert and Mehek Gilani, both of them. They are our associate attorneys and team leads. They are going to talk about NIW. But before that, so as you know, there are 2 major categories of EB2. The regular one requires you to have a job, and your corporation is going to sponsor you. You cannot apply by yourself. There are 3. Let me share my screen so you can have like a idea what I'm talking about. Yeah. So yeah. So I'm going to talk about this EB2, the regular one, and then the NIW would be the next discussion. For regular EB2, you must have a employment, and your corporation is going to sponsor you. And there's 3 steps. The first one is called PERM. So first one is with Department of Labor. So when any corporation sponsors a foreign person, and by foreign person, it means anybody who is a international student or here in America with any kind of visa, or someone living in a foreign country. So basically anybody who is neither a US citizen nor a permanent resident is considered a foreign person. So when a corporation sponsors a foreign employee, they must meet 2 criteria. Number 1, they are not depriving a qualified American person, American citizen or permanent resident. Number 2, they are offering the same benefit and work environment they would offer to a local person. So the first step, PERM, it basically makes sure that the corporation is treating a foreign person 100% equal to a local person in terms of hiring, in terms of salary, in terms of bonus, in terms of everything. So I'm not going that detail. If you have any question, we'll answer later, because I'm trying to make this presentation shorter so that you're not bored. But if anybody has any question about PERM process, then I'll definitely discuss. The second step after PERM approval is called I-140. I-140 is usually a short process. There's a premium process. If you take premium process, you'll get I-140 approved within like a month or 6 weeks. And usually those whose PERM is approved, their I-140 would definitely be approved in almost like a 99% case. The third step is I-485/IVP, meaning if you are in America, your third step would be I-485. If you're living in a foreign country, it would be IVP. Some people call it consular process, meaning you're going to apply for visa in a US embassy in that particular country. Sometimes there is a waiting period before this I-140 is approval and before you can apply for I-485. It depends on the visa bulletin. So visa bulletin is a different kind of discussion. I'm not going into detail. I just want to tell you that every month, Department of State publishes this document, visa bulletin, and visa bulletin is kind of the gatekeeper of American green cards. So no matter what is your category of green card application, is it family-based, employment-based, and even within family-based and employment-based, there's some different subcategories. Your country of origin, it depends on when you'll be able to apply for the actual green card. So understanding how to read visa bulletin is sometimes a little difficult, but we have separate video. By the way, let me tell you some. So we have a YouTube channel. It's called Attorney Raju Mahajan and Associates. We discuss about many topics in that YouTube channel. We have more than 100 videos. I invite you to go check our website, our YouTube channel, and we have a video about how to read visa bulletin. So bottom line is, after I-140 is approved, depending on the visa bulletin, you'll be able to apply for I-485/IVP, depending on your country of residence at that moment. Once your I-485 is approved, you get green card. So this regular EB2, just remember one thing, you must have employment and your corporation is going to sponsor you. You cannot apply by yourself. On the other hand, NIW, National Interest Waiver, you can apply by yourself. And nowadays, I would say more than 80% of international students, they get green card through NIW. Before I go into NIW discussion, I'm inviting Rachel Gilbert and Mehek Gilani to talk about NIW in short, because NIW is a big discussion. We don't want to go that detail. Let's say 10 minutes, and after that, we'll come back for another topic.
Sure, thank you. I believe Chelsea will be sharing her screen for the presentation. Hi, everyone. Thank you for taking time out of your day to come to this seminar. My name is Mehek Gilani, and I'm an attorney at Raju Law, along with Chelsea, Rachel, Anna, and obviously Raju. And now Rachel and I will be speaking about the EB2 visa and specifically the NIW visa, which stands for National Interest Waiver. This is a visa based on exceptional ability or having an advanced degree. And you can change to the next slide. Thank you. So for the NIW, we as your attorneys would draft a petition that is typically around 30 pages long with many exhibits on top of that. The first page of the petition looks like what you see here on the left. And we draft this petition and provide all the evidence to USCIS in an effort to show them that you have this exceptional ability and that makes you capable to impact American life in a positive way, or that you can use your expertise to solve some sort of issue in the United States. And this can look like an engineer who is well-versed in building bridges and how the US needs this person's expertise because many of the bridges in the United States are in poor condition. But also the topics don't have to be STEM related. This petition is particularly valuable because it's a fast track to a green card, and we'll get to the processing times a little bit later. But it's a fast track because the NIW is essentially requesting that the job offer and labor certification be waived because it's in the interest of the United States to let this person in and work. And this waiver allows people to self-petition without requiring an employer sponsorship, which is particularly advantageous because then you wouldn't have to be reliant or dependent on your employer for your residency. And it will also just give you a lot more movement within your career. Next slide, please. So in order to be eligible for this fast track waiver, you need to have either an advanced degree or be a person of exceptional ability. And I believe everyone here would have the advanced degree. So the advanced degree is either a bachelor's degree along with 5 years of progressive experience, or it's a master's degree and higher. And to meet the exceptional ability prong, you would have to meet 6 out of 3 criteria. But even if you meet the 3 criteria, that doesn't necessarily mean that you'll be automatically eligible. It just means that after you meet the 3 criteria, the officer will then determine the weight of the evidence and then determine if you met your burden of proof. And the criteria includes academic records showing you have a degree, 10 years of full-time experience, a license to practice in your profession, such as a professional engineering license, evidence of a high salary, membership in professional associations, and a recognition of your achievements. So again, you would only have to meet 3 of those. Next slide, please. The proposed endeavor is something we submit along with the petition itself. It's arguably one of the most important parts of your NIW application, and it's a 3 to 5 page document outlining the details of your plan in the United States. It speaks to what issue you aim to solve or how you will improve something in American life, and it has to be related to your field and your experience. So your CV is often considered while we draft this document. The PE should be very specific. We want to make this document technical because USCIS does not want to see idealistic endeavors. They want to see enough details to show that you have exceptional ability and have realistic goals based on your expertise that you are capable of achieving. So in this proposed endeavor, we often outline the 5-year goals, the 10-year goals, and just speak about the progress you've had in the past just a little bit, but overall it's mostly forward thinking. And even though we want this proposed endeavor to be technical, it also has to be simply written such that a USCIS officer can understand it. And that's when our expertise comes in. because a lot of our clients are often very well versed on their topics and their field. And so we work with them into simplifying their topics such that a layperson can understand what they do through this document. Next slide, please. The petition itself that we draft for you has 5 components. The first one speaks to your eligibility, which is either the advanced degree or the exceptional ability. Then we move on to the factors that USCIS considers for the national interest waiver, and that is that the proposed endeavor has both substantial merit and national importance. We put those things together and it just explains why what the client is doing is important and how it aligns with national initiatives related to the proposed endeavor. Then we move on to well-positioned, which is just saying that you are capable to advance this proposed endeavor based on the progress that you've made, based on your certifications, your skills, your advanced education. And then we end with the on balance section, which says that U.S. workers will not be negatively impacted by your admission into the country, because overall it would be beneficial to the United States to waive the requirements of a job offer and the labor certification.
Hi, everyone. I'm here to speak on the letters of recommendation premium processing. Thank you so much for your time today. As far as the letters of recommendation go, USCIS does favor independent letters, which would be coming from an expert in your field that you have not worked directly with. This shows a lack of bias. It shows far more support when it comes to preparing your case and showing that your proposed endeavor is going to be innovative, novel, provide something that the US doesn't currently have, and will solve a problem that will have a broad, far-reaching implication. Of course, we also want to take advantage of explaining your prior work and the methodologies that you've used in the past and how those can benefit you in the future. The additional perspective is helpful. It also lays the groundwork of your industry or your field. And we typically recommend having 6. Don't worry if it seems intimidating. You want to make sure a lot of really crucial information is included in these letters. With our firm in particular, we work with our clients to make sure that they're drafted in a way that USCIS typically looks very favorable on. So a lot of the heavy lifting is done for you. Having 6 distinct letters that are not repetitive is crucial, and that process is definitely not something that you'll be left to on your own, and can absolutely bolster your case. Next up, I will help explain premium processing. Part of one of the benefits of the NIW is you can elect to do premium processing. People often wonder, will this affect the outcome? Will this make me susceptible to a request for evidence or help me mitigate that possibility? It does not have that type of implication whatsoever. It simply puts a timer on USCIS to provide an answer, either an approved petition or a request for evidence within 45 days. So if you're a person that wants a response as soon as possible, or an employer wants to see an improved NIW for an official job offer, this can be highly beneficial. Absolutely. Do be aware also, it does not impact your priority date. As far as the approval rating for NIWs for 2023, which is our most recent statistic from USCIS, we had just over an 87% approval rating, which is fantastic. That's a blended approval rate for STEM and non-STEM. STEM typically is higher, something to keep in mind as well. Additionally, the processing times for standard processing will depend on which office the application itself is being sent to, and where you intend to work will impact which of the two offices your application will be sent to. That current timeline is either 9.5 or 11 months for 80% of standard processing applications to be processed. We don't have any further information on that from USCIS. And sometimes it can be longer. It can be shorter. It just simply depends on USCIS's workload and their backlog. Do be aware as far as what kind of timeline you'll be looking at when you're working with an attorney. It can vary substantially firm to firm. We're very proud to say that we look roughly between 55 to 60 working days from initial retainer to submission to USCIS. That's, of course, with assisting with the proposed endeavor statement and all LORs as well. Also, do be aware that the premium processing fee does not include the actual application fee as well. And new this year, there is also an asylum program fee. So the application fee itself, standard processing, is twofold. There's the asylum fee, which is $300, and the filing fee, which is $715. So application fee plus premium processing totals to just over $3,800. Thank you.
And that wraps up our part of the presentation. Thank you so much.
Yeah, thank you, Mehek, and thank you, Rachel, for a wonderful presentation. Now I'm going to invite Anna Quintero to talk about EB1. And those who are watching our presentation from UNCC, I know it's a long conversation and a lot of topics. It's very hard to get everything at a time. That's why after this presentation is done, we're going to send a copy to all of you, copy of the recording through Jill's Office of Graduate Learning, so that you can watch it later and learn about particular thing that you really care about. I invite Anna Quintero to talk about EB1.
Thank you so much, Raju. I'm going to share my screen. If you could just give me one moment, please. Okay. Are you guys able to see my screen, the PowerPoint?
Yes. Yes.
Okay, thank you. So my name is Anna Quintero. I am one of the attorneys here at Raju Law, and I'm just going to go over EB1A visas with you. So what is an EB1A visa? This is an immigrant visa for people that have an extraordinary ability in the arts, sciences, business, education, or athletics. This is a much higher threshold than that of the NIW, which is for exceptional ability. Extraordinary ability, what it means is that you're one of the select few people who have risen to the very, very top of your field, which is what makes it such a high threshold. And in order to obtain one of these visas, you must show that you have this extraordinary ability and that you will continue to work in the field of your extraordinary ability upon coming to the United States. Now, some of the benefits of this visa are that, like the NIW, you don't need a US company sponsor, which means you don't need a US job offer or a labor certification, and you can self-petition. Additionally, because this is an immigrant visa, if you are successful in the application, if your EB1A gets approved, you, your family, and unmarried children under 21 years of age are eligible for a US green card. In addition to these benefits, this is also a type of visa that is eligible for premium processing, which means that this type of petition, once it is submitted, it will be reviewed and a response will be issued within 15 days of it being submitted. Now, like the NIW, this premium processing fee is on top of the application fee. And currently it's $2,850. And of course, this means faster processing times now, because this is you have to meet such a high threshold for the extraordinary ability that adds to the faster processing times because less people qualify for this visa. Now, the requirements for an EB-1A. You have to meet, of course, the extraordinary ability in sciences, arts, education, business, or athletics. Like we covered, you have to be coming to the US to continue working in the field of said extraordinary ability. And additionally, you have to show that your entry to the US will substantially benefit the United States. Now, in order to prove an extraordinary ability, you have to provide evidence that you have sustained national or international acclaim and that your achievements have been recognized in the field of expertise. So, in order to prove this, there are two ways. You can show a one-time major achievement, international major achievement like a Nobel Peace Prize, an Academy Award, Grammys, something really, really extraordinary. Or if you don't meet this prong, you can also satisfy 3 of the 10 evidentiary criteria listed in the USCIS website, which you can see here. Some of them, of course, are national or internationally recognized prizes, judging the works of others, relating to your field of expertise, being a member of a professional association, etc. Now, how does the USCIS decide whether to approve or deny your petition? So not only must you meet the evidentiary threshold, but also the final merits are a big deal, which is the totality of the evidence provided, whether or not it actually reflects that you meet the extraordinary ability prong, which is very, very important. So not everybody that meets the 3 out of 10 criteria necessarily meets the extraordinary ability prong. Now, the documents that are required for filling out your EB-1A petition, they do depend based on the criteria that you satisfy. So we do have to meet on an individual basis to review which prongs which criteria you satisfy, and based on that, we would gather the information required in order to fulfill the criteria and get your petition filed and submitted. This is a really great opportunity. This is a really great visa for the candidates that qualify. Now, like I said, this is a much higher threshold than the NIW. So it is important to potentially take both of them into account. And once looking at both, then if this is the one that you also satisfy the criteria for, this would be a great option for you. Thank you so much. And if you have any questions, please let me know.
Thank you very much, Anna. I'm going to share my screen. Anna,
Yes,
can you please?
Yes.
Okay. Yeah, thank you very much.
Thank you.
All right. So thank you very much, Anna Quintero, for a great presentation on EB-1A. There are 2 other EB-1s. So let me go through very short about those 2 other. So there's the EB-1B and EB-1C. After that, I'm going to talk about airport immigration service, and then we'll be open for question answer. In the question answer section, Mehek, can you please read this question, and then all of us will answer, because I have like some eye issues. It's difficult for me to read small writings.
Sure.
So.
Yeah.
Yeah, thank you. So as I said, there is EB EB1B and EB1C. So EB1B is for tenure track professors and full-time researchers. And you cannot apply by yourself. NIW and EB1A, these two applications, you can apply by yourself. You do not need any sponsorship. On the other hand, EB1B requires a sponsorship from your university or your research organization. So those who are tenure track professor in your school, you can talk to them, and if they're interested to sponsor you, then it's a comparatively very easy process, especially if your university, either a public university or non-profit university, is kind of like a sure shot. Research, full-time researchers. So not all postdoc programs are considered as a full-time research position. Some do. Those who qualify for full-time research position, they can also apply, meaning their university can sponsor them. Also, if you work for some national labs, there's a lot of national labs in America. If you work for a national lab and if they want to sponsor you, definitely you can get approved under EB1B. Also, a lot of corporations, especially big corporations, they have R&D departments. So if you are a full-time researcher of a R&D department of a corporation, your corporation can also sponsor your EB1B. I'm not going into detail because it's very specific to organization. It's very specific to the position. So, but just bear in mind that for EB1B, you must be a tenure track professor or a full-time researcher, and you must be sponsored by your corporation. You cannot apply by yourself. EB1C is for multinational executives of a multinational corporation, meaning, let's say, Google corporation has offices all over the world, and let's say you are employed by a Google's, let's say, India office, and then Google want to transfer you to their America office and can sponsor you. It doesn't have to be like a giant corporation like Google. A lot of small or medium corporations, they can also sponsor you, but the position must be at least a mid-level executive or like an upper-level executive. In general, an entry-level executive will not qualify for EB1C. However, sometimes it's case by case. Sometimes even a small position holder can get approved depending on the responsibility. If your responsibility is very significant for the corporation, you can qualify. The last topic before we go to our question answer is airport immigration service. Oh, by the way, so our firm, we do pretty much all kind of immigration, no matter whether you are an international student, you're from, you come to America with other kind of visa, for family-based, marriage-based, you name it. Like for all kind of immigration, we provide service. So if you need any help, if you or your friends, let us know, we'll try to help you. So airport immigration service is kind of like a unique service that our firm and few other firms we offer. A lot of time, international students and other immigrants, when they come back from international tour or even first time, they feel like, they are not ready to be questioned by the airport officers. So sometimes they feel bad. So they can retain us. And once they retain us, they must let us know, let's say they're landing in JFK airport, or let's say in Washington, D.C. airport at, let's say, 4 p.m. Wednesday sometime, blah, blah, blah. So one of our attorneys will be ready. We will have all of your documents, all of your papers in front of us. When you you pass through the immigration service, if they ask you like a basic question, it's okay, you can answer those. If they ask you any question that you are not comfortable about answering, you can say, I have an attorney, my attorney wants to talk to you. Then you'll have a phone number from our office. You can call us. One of our attorneys will talk to the officer and try to answer all of your questions. So many times it happened, people retained us, and we even don't need to do anything. We just sit there, wait for any unforeseeable situations. If nothing happened, you'll go through immigration, no problem at all. But if you need help, we are there to help you. And it's a very inexpensive service. We do not charge a lot of money. However, if you need this airport immigration service, we are here to help you. All right, thank you very much. It's a long presentation. I know a lot of information, but the purpose of this presentation is just to give you an overall idea about different types of immigration. If you have any question, you can either unmute yourself and ask question directly, or you can type in the chat box. Mehak is going to read it, and we all will try to answer it.
So the first question is whether the bachelor's degree needs to be from a US university or if it can be from another country. And this is specifically for the NIW, so I can answer it. So a bachelor's degree doesn't need to be from a US university. It can be from a foreign country. But if it is from a foreign country, it would need to be evaluated. And we use World Education Services, otherwise known as WES, to evaluate foreign degrees to confirm it's equivalent to a US degree. But if you have a foreign bachelor's degree and a master's from a US institution, then you don't need to get the evaluation for the bachelor's.
Thank
For
you.
the NIW, the next question is for the NIW, does one have to attain the graduate degree before applying? Yes, because it's either it's either an advanced degree or it's exceptional ability. So if you're in the middle of getting your graduate degree, then you can get the degree and then evaluate for it. Or you can try to go through the exceptional ability route, which is when you have to have 10 years of work experience along with a few other criteria. If you have any follow-up questions, please feel free to take yourself off mute. This is a question for the STEM Masters. I have a question for the STEM Masters, Cybersecurity MS in my case. As a current student, when applying for a job internship, in the question, are you legally authorized to work in the US? Do I have to select yes or no?
So it's a good question. Until you receive the work authorization. So let me give you an example. So let's say you are graduating in May of 2025 and you applied for OPT, let's say in February or March of 2025, you can apply for OPT before 3 months of your graduation. Then you can say, yes, I have work authorization, because even though you did not receive the card in your hand, but getting OPT approved is like a 99.99% chance. So you're definitely going to get it unless something bad happens. Then you can say, yes, I have work authorization. However, before applying for OPT, let's say January 2025, you did not apply for OPT yet. Then you say, no, I do not have work authorization because you even did not apply. So it depends case by case, but unless you are like, sure shot that, yes, I'm going to have another example, like H1B. H1B is not guaranteed. It's a lottery. So even though your corporation applied for H1B, until you get I-129 approved, you cannot say that I have work authorization. So it depends on the situation, but if you know that you're going to get it for sure, then you can say yes, even though you did not receive the card yet.
Next question is, what will happen if after my graduation, if I find a company and sponsor, we'll lottery, but we cannot win. So my CPT done and I have no more options. And this is in regards to a Master of MBA, not STEM.
Yeah, so this is a very common scenario. A lot of people, they, after their graduation, they take OPT, they get a job, and let's say either the corporation is not sponsoring H1B or they are sponsored, but you did not win the lottery. So this is a very common situation, and a lot of people sometimes they apply for day one CPT. I explained in the beginning of this presentation. If you join later, you can watch this video again. So day one CPT is a good tool in this situation. Also, a lot of students, they go back to education for a PhD program or masters of a different program. Like, you already have an MBA. This time you can go for, let's say, masters in IT or, some other field that is more job friendly kind of field. Sometime, there are some agency, they can sponsor you. So there are many options depending on your situation, but don't worry, there's always something there. So one thing I tell my clients and my friends, American immigration system is very student friendly. So no matter what happens, there's always some options. So don't worry, you'll be taken care of by the government.
Next question is, to apply for an OPT, do I need to get a job? And for getting the work extension, do I need to get a job offer or just need to request the extension? This is for STEM.
Yeah, so the first OPT, first 1 year of OPT, you do not need a job. You can apply by OPT by yourself without any job confirmation. However, once you receive the OPT approved, there's a starting date. You put a starting date. So let's say you are graduating in 15 May 2025, and you set up your starting date, let's say July 1, 2025. So from July 1, 2025, you have 60 days to start your job. So a lot of time, what happens is when you apply, like 3 months before your graduation, you will start searching for jobs. And let's say you're not in good luck, you did not find job, and your starting date is already passed. So you already passed July 1, and your 60 days clock has started. So every day you're losing a day. If you do not find a job, at least talk to your professor, your supervisor, and offer them, like, you will do unpaid unpaid assistant, research assistant kind of position. So if your professor write a letter that he or she is working as a research assistant under me, that will also suffice the job requirement. Also, there's a lot of non-profit and for-profit corporations. They will be happy to hire you as the unpaid intern. That will also work for first 1 year of OPT. However, for the STEM extension, you must have a paid job, and you must mention about that paid job's employment. Unless you have a employment for a paid position, you cannot extend for 2 years of extension. So first 1 year is basically you can get a work authorization, then you can try to find a job, even though it's recommended to try to find it earlier. But for the second year, like 2 years of extension, you must have a paid position before you even apply for the extension.
The next question is how many articles and situation I should have for MBA to apply for NIW for master's, and how long it takes to take my green card since I applied with premium.
So since it's NIW, either Mehek or Rachel, you can answer.
Oh, sure thing. As far as articles and citations, it's not technically a requisite. Of course, the more publications, the more reputable of journals that you have, it's a stronger profile. However, a lot of our master's clients don't have that research backing because it's not typical with their programs, and that's okay. So we take an alternative approach and make the NIW more project focused, and we see a lot of success with that. So if you don't have a strong research backing, please don't let that deter you. We work with our clients from all different backgrounds, and we'll definitely make it work. And to the second part of your question here, it depends on your green card with the priority date. So that will be the requirement. The approval with premium processing, again, that's simply merit-based for the petition itself. It doesn't accelerate the green card process by any means. So you'll want to just keep an eye on the visa bulletin in that regard. Thank you.
Thank you. Thank you, Rachel.
Next question is, I'm going to apply for OPT now. I am going to graduate in December of 2024. And when I am applying for a job and company is asking, do you now or in the future want sponsorship? So should I answer yes or no? So for EAD, do I require company sponsorship?
You do not require, and whether you should tell them whether you require sponsorship or not, that's a very subjective question, because a lot of, like, a big corporation, like, let's say Bank of America, Chase Bank, Google, Microsoft, they are very well aware of this kind of situation. And most of the time, their typical answer is, well, it depends. If you perform good, we're happy to sponsor you, because every year we literally sponsor thousands of people. And if your performance is not good, then probably will not sponsor you. That would be like a response from either mid-size or large scale corporation. A lot of small corporation, however, it's very, because either their CEO or their top management have no idea about OPT, CPT, or any other immigration matters. Sometimes they are kind of like shy about talking about it because they don't know. So if it is a small corporation, it's like mom and dad kind of corporation. So in that case, I would say, no, you do not need a sponsorship. I can work under my OPT. And then when you get your job, try to make a good relationship with your boss and try to explain the situation to them and make them understand that this is not a rocket science. It's very easy. Most of the US corporations, they sponsor employees. And if you can convince them, then talk about the sponsorship. Because if you tell them about a sponsorship upfront, and if they're not comfortable about it, if they do not know it, they'll probably reject your application. So in a small corporation, the first thing would be to get a job, have a good relationship, make them understand, and then you convince them about sponsorship. One thing I can tell you, if you see that your supervisor, your HR, or your boss has no idea about anything, you can email me. I can sit with them. I can explain the situation to them. And a lot of times they're scared about sharing their, tax file and other, sensitive documents. So I tell, small corporation CEOs and HR people that they are not going to share with USCIS any document that is not already publicly available, meaning they are only going to share document with USCIS that they already shared with IRS. So it's not anything confidential or anything. And of course, on the top of that, we have attorney-client privilege. We take care of all of the documents and information very seriously. So there's no way that corporation's business secret or anything is going to be uploaded to a place that is going to be published to like a general public. So short answer to your question, it depends on many factors. If it's a big corporation, medium-sized corporation, you can express your interest for sponsorship. If it's a small corporation, if you're not sure whether your boss knows about it, you do not need to tell them. But later, with a good relationship, you can explain.
Next question. Could you please advise which option would be more beneficial for applying for a green card, EB2 or NIW, if the company is willing to sponsor the EB2?
So I would apply for both because sometimes company-sponsored regular EB2 takes way longer than anticipated. And on that note, let me explain you. We as attorney, we have responsibility towards our client. In a regular EB2 case, our client is the corporation, not you. So a lot of time, and I don't want to say anything bad about CEOs and other people. Sometimes they will say, hey, I really like this guy. I want to keep him as long as possible. Can you please make the process a little longer? And me as an attorney, my job is to listen to the CEO, not you. So we make the process a little longer so that you can stay in that position for longer than you anticipated. And some corporations, they're very fast. Some corporations also sometimes they take way longer time just to send us a document. So let's say we need a copy of the last 2 years tax file. Some accounting department will send us within a couple of days, and sometimes some accounting department will take 2 weeks, sometimes 2 months. So that will make the process longer. So my understanding is that sometimes it may be longer than it should. So to be on the safe side, since NIW application, you can control it 100% by yourself with the help of your attorney, of course. So I advise, unless you have some financial issue, to apply for both parallelly. And whichever goes fast, you will follow that priority date. And let's say once your LC is approved, I-140 is approved under regular EB2, then you can withdraw your NIW application. Or if your NIW-based I-140 is approved, you can withdraw your PERM-based regular EB2, but initially you can go parallel, hand in hand.
Next question. I am a research assistant. How does this influence the whole H-1B process?
So for Chelsea, let me answer this. So for H-1B research assistant or anything, it doesn't make any difference. So for H-1B, the basic requirement is a corporation is going to sponsor you for the lottery, and the position they're hiring and your education or training must match. So if you are a research assistant, you must have a bachelor degree, of course, and then whatever your field of study is. Let's say you are a research assistant in the field of chemistry, and you found a job in chemistry field, and your position is, let's say, entry-level scientist, a chemist kind of. That's okay. Then research assistant is neither going to help you nor going to harm you. So it depends on the job title and your education or training.
Next question. Which companies are better for sponsorship, big companies or smaller ones?
Of course, big corporations, because they have way more financial ability. So Another important information: anytime any corporation they are going to hire a foreign person, the biggest factor is the company's financial ability. If they make a lot of money, if they make tons of taxes, and also if they're like a famous corporation like Google, Microsoft, Facebook, 99.99% of their application get approved, because USCIS officers, as soon as they see the logo, they're like, oh, it's a big corporation, it's okay, let's get it approved. On the other hand, small corporations, sometimes they do not show all of their income. Sometimes they try to pay less taxes and other things. So however, not all small corporations are like that. I know some very good small corporations. They're very good in their bookkeeping and other things. So short answer to your question, big corporations are always better for sponsorship.
Next question, can you talk about nonprofit companies, whether they have lottery for sponsorship?
Yeah, let me answer this one too on behalf of Chelsea. So not all nonprofits are qualified for exempt from a lottery application. So the requirement for exempt from lottery is those who are a research institute like universities or somehow affiliated with research activity. Meaning there's a lot of nonprofit organizations, they do not do any kind of research, but they have certain kind of partnership with the university, and with the partnership with the university, they do some research. Sometimes universities get data from some nonprofits. So let's say, let me give you an example. So let's say there is a senior living facilities next to a UNCC. I'm just giving like a fake example. So let's say there's a senior living facilities next to UNCC, and UNCC is, let's say, Health and Human Security Department. They get a lot of data from that senior living facilities for their research. And senior living facility not only provide this data, but also take part in the research, and also take some sort of benefit from this research. So there's an active participation between the university and the senior living facilities. In that case, both university and the senior living facilities, they can apply for H-1B without any lottery. However, if the senior living facility is only providing data but not actively participating in the research mechanism, then only the university can apply without lottery. Senior living facilities, if they want to apply for H-1B, they must go through the lottery. I hope I made it clear, but it's a little complicated. So the tricky part is the active participation with the research.
That's all the questions that I see in the chat, but if anyone has any more questions, please feel free to put them in there or take yourself off mute.
Yes, and I thank everybody, especially Jill and her office, UNCC Graduate Learning Department. They're doing tremendous, great job. Jill, back to you.
Well, thank you. Thanks to you and all of your team from Raju Law for giving us all of this valuable information, and for the years of relationship and supporting our students, including in 3-minute visas. And I'm going to put one more link in the chat about how to register for 3MT. It's an incredible experience. And I think, Raju, your sponsorship of 3MT came from your conviction that even in the visa process, often students need to be able to succinctly explain their research to a non-specialist. Am I correct?
Yes, 100%, especially for NIW. So I tell that to everybody, like, not only for immigration, for every part of a scientist's life, if you can communicate better, if you can express your research and finding in a more communicating way, you can get benefit in immigration process, you can get benefit in getting job or anything. So yes, short answer to your question, yes, it is very beneficial for general immigration, also NIW application.
Yeah, so thank you. And to everyone who joined us, thanks for your time today. We'll be distributing a copy of the recording.
Jill, one last thing. Did I tell your office name correctly? I feel like I said it wrong. The name of your office.
Center for Graduate Life and Learning. I think you were close, but not perfect.
Sorry about that. Yes, thank you, Jill, and thank you, Center for Graduate Learning and
Well,
Like,
that's our pleasure. Thank you for doing this. Okay.
thank you. Thank you, everyone. Have a wonderful day.
Raju, there was one more question if you want to stay on a little bit after everyone
Yeah,
leaves.
sure.
So the question is, what about the waiver of exchange visitor to your home country for J1?
Yeah, so that's the whole discussion. Sorry, I should talk about J1 earlier, but yeah. So let's give you like a short description about J1. So J1 is sometime kind of like similar to F1, but J1 are for scholars. You are not coming here as a student. You're kind of coming here as a scholar, sometimes as an employee. Some J1s are very similar like F1. You do not have a 2-year home requirement. On the other hand, some J1s have 2 years home requirement, meaning after completion of the purpose, completion of the program, you must go back to your home country and you must serve your country for 2 years before you can apply for US green card. Now, it doesn't mean that you cannot change your status from J1 to other non-immigrant status here in America. You can do it. Meaning, so let's say you are here for J1 and you came for 3 years. After completion of 3 years, you can transfer from J1 to F1 or H1B or other non-immigrant categories. You cannot transfer to a green card unless you serve your country for 2 years. Now, there is a waiver process. Sometimes some countries, they are like, it's okay, you do not have to come back to serve our country. If you stay there and if you do good things, we're very happy about that. So some countries, they're very flexible about giving waiver. So the waiver application has 2 steps. The first waiver you must take from US Department of State, which is very easy to get. And then you must get waiver from your home country's embassy here in America. Some countries, they're very flexible. However, some countries, they have said, no, we are not giving you waiver. We sent you to America, you get some education and learning. So now please come back to your country, serve your country for 2 years, and then do whatever you like to do. In that scenario, you can still apply for waiver under certain circumstances. Some are like, let's say you are a graduate of, let's say, nuclear science, and your country has no nuclear facilities at all. They have no capability about nuclear. So then you can apply for waiver in Department of State, say, hey, I have this knowledge and skill, and if I go back to my country, there's no way I can serve my country because they have nothing. So that's one kind of waiver. Another kind of waiver is, let's say you are employed by some US department, some US government, and your contribution is really, really very critical for their work. So let's say you have been employed by Pentagon or Department of Defense or some environmental protection agency, and you are doing some very critical work. Then the US government will say, it's okay, you do not have to go back to your home country. You can stay here and you can serve America. We will be satisfied. Also, another kind of waiver is, let's say a situation has changed in your country and the current government is very hostile towards you for some political and some other reason. You can also apply for waiver. So there are many other ways of waiver. I'm not going into detail. It depends on your background. Short answer to your question, if your J1 has 2 years home requirement, before you apply for green card, either you have to get waiver or you have to go back to your home country.
And they have a follow-up question. If I change to an F1 visa, will the 2-year home country rule still apply? And for the waiver,
Yes.
I need it from 2 parties, the US Department of State and my embassy's country, correct?
Yes. No matter which, so no matter you go to F1, O1, L1, P3, or any kind of non-immigrant categories, your 2-year home requirement will remain until you serve your country for 2 years or you apply for waiver.
I believe that wraps up all the questions, at least in the chat function. Thank you so much.
Thank you very much, Mehek. Thank you, everyone. A special thanks to Jill, and also a special thanks to Aura. She's not here today, but I'm going to see her in November.
Looking forward to it.